Welcome back to The Explainer, everyone. Listen, to all the 1L and bar prep students tuning in right now, get your highlighters ready because today we are delivering an absolute masterclass on tort immunities. We're going to look at exactly how these legal shields operate, why some of them are completely falling apart in modern courts, and most importantly, exactly how you need to attack them on a final exam. If you've been struggling to figure out when a defendant gets to walk away completely off the hook for a tort, well, this is The Explainer for you.
All right, here is our attack outline for today's explainer. 1. The shield of immunity. 2. Abrogating traditional immunities. 3. The parent-child divide. 4. Discretionary versus ministerial acts. And 5. Mastering key practice scenarios. Let's get into it.
Kicking things off with Section 1, the shield of immunity, status over conduct.
So, look, the absolute crucial point we need to establish right away is distinguishing between an immunity and a defense. This is a trap a lot of students fall into, so pay attention. A defense, like, say, comparative negligence or assumption of risk, evaluates the actual conduct of the plaintiff, right? Like, did they act reasonably? Did they know the risks? An immunity, on the other hand, literally does not care about behavior. It is a status-based, complete block to tort liability. It depends entirely on who the defendant is or their specific relationship to the plaintiff. If an immunity applies, the lawsuit is dead in the water, period. Even if the defendant was clearly, obviously negligent.
Moving right along to Section 2, abrogating traditional immunities, the fallen shields.
Historically, if you were a charity, a spouse, a parent, or the government, you were basically bulletproof in tort law. But look at the modern judicial trend on this slide. These traditional shields are heavily diminished. Charitable immunity? Mostly abolished today, because, well, modern nonprofits can just buy liability insurance. Spousal immunity? Also mostly abolished, because courts finally rejected that antiquated fiction that a husband and wife share a single legal identity. But notice the remaining two, parent-child and governmental immunities. Those are actually partially retained.
Which brings us to Section 3, the parent-child divide, surviving the purge.
So contrast these two family dynamics, right? For decades, courts kept spousal immunity alive by arguing that lawsuits would destroy marital harmony. But eventually, judges woke up and realized that, hey, if a husband negligently runs over his wife with a car, the tortious conduct itself has already destroyed the harmony, not the lawsuit. So spousal immunity fell. But in stark contrast, courts intentionally kept the parent-child shield intact. Why? Mainly to prevent judicial overreach into child-rearing. Courts absolutely do not want to micromanage how parents discipline their kids or how they run their households.
Let's actually apply this to a real-world scenario from our sources, the Neel versus Sewell case brief. Picture this. A 17-year-old boy is helping his dad clean up the backyard by burning trash. Pretty standard chore, right? Well, hidden inside one of those garbage bags is an aerosol can. It gets tossed into the fire, it explodes, and the son is severely burned. The son then sues his own father for negligent supervision, claiming his dad failed to safely instruct him on the hazards of the fire. The father immediately throws up the shield, claiming family immunity under Michigan's Plumlee doctrine. And this is just a brilliant illustration of the black-letter law. The son basically argued, hey, making me burn trash without checking for explosives is totally unreasonable parenting. But the court said, actually, that doesn't matter. Immunity evaluates the category of the activity, not the reasonableness of the specific behavior. Think about it. If we had to check if the dad was being reasonable, we'd be evaluating a defense, not an immunity. Assigning chores and supervising a teenager tending an outdoor fire falls squarely into the category of reasonable parental authority. Because it fits the category, the father is absolutely immune. Lawsuit dismissed. Okay. Section 4, discretionary versus ministerial acts, the sovereign shield. You absolutely must sharpshoot this distinction if you want to ace your finals. When the Federal Tort Claims Act waived absolute sovereign immunity, it kept a massive, massive exception. On one hand, the government cannot be sued for discretionary functions. If a government agency is making high-level policy, allocating budgets, or designing safety regulations, they are completely immune. We just don't want courts second-guessing democratic political choices. Conversely, ministerial acts are not immune. If a government employee is just doing routine, day-to-day physical maintenance or executing an established policy, the government is fully liable for their slip-ups, exactly like a private corporation would be. So when you're analyzing the Federal Tort Claims Act, I want you to always march through this two-part test to determine if the government's action was truly a protected discretionary function. First up, the discretion-prone prong.
Was the employee allowed to make a choice, or did a mandatory statute tell them exactly what to do? Like, if a rule says inspect the brakes every 30 days, and they don't, there's zero discretion there. They are liable. Second, the policy substantive prong. Even if they did have a choice, was it a choice grounded in social, economic, or political policy? Deciding whether to build a massive bridge? That's a policy choice. Deciding to drive a government truck recklessly down the highway? That is not a policy choice.
Let's bring it all together in Section 5, Mastering Key Practice Scenarios. Iraq in action.
Here's a fantastic exam hypo drawn straight from the Whisnant versus US case. A worker at a naval-based commissary develops a severe respiratory illness because the meat department is literally infested with toxic mold, and the government ignored the slime and standing water for 3 whole years. When they get sued, the government argues, hey, allocating our cleaning budget is an economic policy choice. Therefore, we have discretionary immunity. So, do they win?
Now, apply your IRAC right here. The issue is whether cleaning mold is a protected policy choice or just a ministerial act. The rule is that two-pronged test we just learned. In its analysis, the Ninth Circuit sharply distinguished the design of safety rules from the operational implementation of those rules. Deciding how to set up a safety program, sure, that's an immune policy choice, but physically removing an obvious hazardous accumulation of toxic mold in a grocery store? Come on, that's just routine ministerial maintenance. There's no legitimate political or economic policy that justifies letting toxic mold fester. The government loses its immunity.
Seriously, drop this exact quote from the Ninth Circuit into your exam to show the professor you truly understand where the boundary line is. Safety measures, once undertaken, cannot be shortchanged in the name of policy. The government cannot just use budgetary constraints as a magical shield to turn a routine janitorial failure into a protected political policy. It doesn't work that way.
Let's pivot slightly to municipal premises liability with the People's case and see who actually owes the legal duty of care. A kid is injured playing on a dangerous, hole-filled baseball field owned by the city, but it's being operated for the day by a private youth baseball league. The league says, look, we don't own the land, so we don't owe any duty to maintain it. Go sue the city.
So the crucial takeaway here, and honestly the rule for your IRAC, is that premises liability doesn't just care about the name on the property deed. A legal duty of care arises from temporary possession and control of the premises. In this case, the sports league exercised exclusive operational control during the game. They directed the kids, they enforced the rules, they managed the whole event. Therefore, they owed a ministerial duty to keep those players safe from obvious hazards during that block of time, regardless of whether the city ultimately owned the dirt.
I'm going to leave you with this final thought to ponder before your finals. We've seen how charitable and spousal immunities have crumbled over time, and how modern courts are strictly limiting governmental immunity to pure, high-level policy decisions. But as the public demands more and more accountability, and as government budgets frankly get tighter and tighter, where exactly will the courts draw the final line? Will the sovereign shield eventually vanish completely, treating the government just like any other private corporation? Think about the policy implications of that as you outline. Keep studying hard, trust your IRAC structure, and we will catch you on the next explainer.